understand me. You don't understand me. If I was a different color, you would. And it's true.
That's so
it's
not.
so true. It's so true. And you know this. You know what I'm talking about.
Yes, sir.
I want you to know, I don't know anything about your case. All I know is that you've now, as of 3/26, yesterday, you picked up a failure to stop and give information. What happened? Or, well, hold on. You have the right to remain silent. Anything you say can or will be used against you. Okay.
On March 25th, 2025, officers were dispatched to 15357 Wallaceville Road in Heron County, Texas, regarding an FHDI call. Upon arrival, the officer spoke with the complainant, who stated that she followed the defendant after the defendant's vehicle hit her twice and failed to stop and give information. The complainant stated that she was driving southbound on the East Sam Houston Parkway, and the defendant failed to drive in her lane and sideswiped her, causing the vehicle damage to the right side panel of the defendant's vehicle. The complainant stated that she blew her horn several times for the defendant to stop, and the defendant refused.
Buckle up, guys. Today we're diving into a courtroom firestorm, starting with Miss Gil, who bursts out claiming she's misunderstood due to her race. The judge, stone-faced, immediately shifts focus to the new charge, failing to stop and provide info after a crash. And from here, things only get messy, eh?
The complainant followed for approximately 3 miles to 15242 Wallaceville Road, and the complainant and the defendant exited their vehicle, and the complainant told the defendant that she hit her vehicle and needed insurance information. The defendant then told the complainant no, and that she was getting something to eat. The defendant went inside the business, exited, and then entered her vehicle and attempted to drive away. The complainant blew her horn several times to get the defendant to stop and told her the police were coming, but the defendant ignored the complainant. The defendant then began to put her vehicle in reverse and proceed backwards, hitting the complainant's vehicle a second time. The complainant—
So are you telling me that now it was intentional?
Sure. The complainant moved her vehicle to avoid being hit and followed the defendant. The complainant flagged the police down to identify the defendant as the person who struck her vehicle. The estimated damage from the complainant was around $4,000, and the defendant stated she didn't stop because she was hungry and colored.
And what?
Colored.
Colored?
Yes, Your Honor.
The courtroom hears how Ms. Gil allegedly struck another vehicle not once, but twice. After being confronted at a restaurant, she tries to flee, only to reverse and hit the same car again. The judge cuts in, questioning if this was intentional. The air gets tense. Accountability is about to land hard.
Can you look up to see if she has a valid Texas driver license?
Yes.
Ms. Gil, I'm going to find that there is sufficient probable cause to go forward with your case. Not only are you on a felony probation for assault of a peace officer, not only are you on felony probation for injury to a child under 15, but you pick up, after both of those, an evading arrest in a motor vehicle, and now an FSGI. I am taking away your privilege to drive. You will now be signing an affidavit with me today, promising me you're not going to drive. I don't give a rat's behind what your excuse is. If I find that you drive in violation of this affidavit, I will have a contempt. I can have a contempt hearing. I can have a contempt. After. Finish.
I'm so sorry.
Finish.
I'm a commercial driver.
It's revealed Ms. Gil holds a commercial driver's license, and the judge is stunned. Her legal exposure just got worse. He strips her driving privileges and warns her that if she dares get behind the wheel again, a contempt hearing is next. The stakes are rising fast and visibly rattling the courtroom.
Really?
Yes.
Really?
Yes.
You, if you do have a CDL,
Sorry, that is correct. She does have a valid CDL.
are held to an even higher standard because of that CDL. You now have a total of 4 open cases, one of those being this FSGI and an evading arrest in a motor vehicle. I am taking away your privilege to drive. If I find that you do, I can have a contempt hearing. You can be facing an additional 6 months in jail and a $500 fine.
With 4 open cases, including evading arrest and prior felony probations, the judge's patience is gone. He reiterates, drive again, and she's looking at 6 more months behind bars. He's not just revoking her rights, he's laying down legal landmines. This is a moment of judicial firepower at full force.
I truly am at a loss with the attitude.
Okay.
Truly.
Okay.
In this case here, not only do we have an FSGI, but it's also alleged that you backed up and hit the person intentionally. Because allegedly hungry and so now this is an affidavit, and I hope that you take it seriously, because if you don't, there will truly be disastrous consequences. Miss Gil, I want you to understand that I'm going to do everything in my power to protect my public at all costs. Do you understand?
I understand you, Your Honor. May I make argument for a PR bond, Your Honor?
The judge zeroes in on public safety, declaring Ms. Gil a risk due to her reckless behavior. He warns her to treat the affidavit seriously or face devastating consequences. This isn't just legal procedure. It's a warning flare aimed straight at someone walking on a razor's edge.
She's made a bond in the felony already. And even with the affidavit to not drive, I expressed to her that that was a possibility of a bond condition. I've spoken with her. She has family members who can help her get to and from court. She's a single mother of 2 children. She has lived at this address here in Houston for the past 5 years. She lives with her mother. She lives with her younger brother. She has lived in Harris County her entire life. And she has, in these felonies, she's actually applied to be put in mental health court because during this incident and the felonies, she was unmedicated and she has a history of mental health diagnoses. And so as a client of the Harris County Public Defender's Office, we have every intention of getting her treatment for those mental health issues.
The defense makes a push for a PR bond. Her lawyer paints the picture. Single mom, mental health struggles, community ties. It's a solid argument, trying to thread the needle between compassion and risk, but whether the judge buys it is another story entirely.
But she's already made a bond in the felony, and she is willing to abide by any condition that this court will impose on her. It's down to the difference between $0 and $100. And
So I appreciate your argument. She's technically, you are right on bond. My feeling is that these felony courts probably do not know that she has now picked up this case yet. So I don't know what, if anything, they're going to do when they do discover this. I find, Ms. Goucher, right? Is that what Ms. Goucher? I really appreciate your argument going to bat for her, but I think with her demeanor, her attitude, her reckless and wanton action on the road, is that you are a danger to the public. And
The judge acknowledges the defense's plea, but isn't moved. With sharp commentary on her attitude and danger to the public, he spikes her bond from $1,000 to $5,000. He says it plainly, she's acting like she'll do whatever she wants. And that mentality ends today.
your bond is now set at 1,000, and I'm going to raise it to 5 because I think that you really are a danger to the public, and your attitude shows us and tells me that, hey, I'm going to do what I want to do, and that's it. And that's always, I mean, really,
Don't say anything.
how many people died this weekend on the road because of the reckless and wanton actions, you know? All we want are our streets to be safe.
You're not helping me, Your Honor. You're not helping
Don't
me.
say anything.
I'm struggling. I'm a single mom, and I've been struggling with the courts for years already, and I'm tired of this.
okay? I was beat, okay, in front of my children, and I was thrown on the ground like an animal, okay? And I'm tired of this. I'm tired of all of this, okay? In front of my children. My children have trauma, okay? And I have no insurance for the medication, and I have not been on the medication. I'm trying to get the insurance to get on the medication.
Miss Gil,
Okay.
I understand that, but at some point, your actions become your own, right?
You don't understand. I'm colored. You don't understand me. You don't understand me. If I was a different color, you would. And it's true.
That's so
It's
not.
so true. It's so true. And you know this. You know what I'm talking about.
Ms. Gil snaps, tearfully recounting abuse, trauma in front of her children, and lack of access to medication. She pleads for understanding. But the judge stays firm, reminding her that while trauma explains things, it doesn't excuse repeat offenses. It's courtroom heartbreak, but also hard truth.
I call out discrimination when I see it on a daily basis, ma'am. I don't care who it is. I don't care what color. If they're a small farm animal, I don't care. I call it when I see it. The only thing, because I don't know, the way I get to know you is paper. And they tell me what happens in the case. And from what I see here and what has transpired here within the last 10 minutes. Really?
Officer Harris did not read me my rights.
Well, I will let
They've been mishandling me like this for years already, okay? I have the right to tell you this. And I'm telling you, she did not read me my rights. She just shoved me behind the officer car. I did not get a voice to speak out anything.
Yes.
She just brought me to jail.
You guys speak about that. I'll tell you, look, here's what I'm gonna do. I'm gonna leave your bond at $1,000 now, all right? I'm not gonna raise it to $5, but I can't continue to give you a PR bond.
From employment too.
Listen,
Okay.
do not drive. It's the only thing I'm asking you to do.
I'm a commercial driver.
Don't pick up a new
Yes,
case.
sir. Yes, sir.
And just,
She accuses the officer of violating her rights. The judge, initially prepared to impose a $5,000 bond, backpedals slightly, lowering it back to $1,000. But his warning is brutal. One more charge, one more drive, and there will be jail. It's her final shot at staying out.
all right. Come on. And you filed an attorney of record?
His attorney of record is Nicholas Gil. It should
Okay.
be filed today, and I'm going to bring this setting as with associate.
Got it. Okay. Morning, Mr. Segundo. Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you, sir.
Yes, Judge. On December 30th, 2024, the officer was dispatched to a possible DWI at North South Houston Tollway in Harris County, Texas. The officer made contact with a witness who stated he observed the defendant's motor vehicle fail to drive in a single lane, driving on the improved shoulder and striking the right barrier wall. The officer observed the defendant's motor vehicle change from lanes 2 to 3 without a signaled the lane change from 3 to 2, and then failed to signal a lane change when going back from 3 to 2. The traffic stop was then initiated, and the defendant's motor vehicle pulled over at a high rate of speed, nearly striking the barrier wall. The officer made contact with the defendant, the driver of the vehicle, and the officer observed a strong odor of an alcoholic beverage, an unstable gait as the defendant walked, and red glassy eyes. The defendant stated he was driving home from being at a party. He had consumed 3 Bud Light beers and 2 vodka mixed drinks 2 hours prior to the traffic stop. The officer administered standard field sobriety tests, HGN 6 out of 6, walk and turn 4 out of 8, 1 leg stand 2 out of 4.
Next up is a new defendant, Mr. Sundo. Busted for DWI after slamming into a barrier wall. He admits to drinking vodka and beer. The judge slams him with a no-alcohol bond condition and random testing, making it crystal clear he's one breath away from jail.
The defendant read the DIC and refused to provide a sample. A blood search warrant was signed and executed.
Just Segundo, I'm going to find that there's probable cause to go forward with your case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming alcohol or illegal drugs, I'm going to revoke your bond, put you in jail. No more PR bonds. Do you understand, sir? Any prior DWIs?
No, Your Honor. And license eligible.
Okay, as long as you have a valid Texas driver license and liability insurance, you can continue to drive. Just be careful. It may become suspended. If it does, you can't drive. You've got a lawyer. Because you do, I'll waive your appearance, but you got to stay in touch with them. They'll tell you when you have to come back to court. If they tell me they can't get a hold of you, I will revoke the bond. So just stay in contact. Don't pick up any new cases and don't use questions. All right, man. Good luck. Come up, Mr. Ayala. Good morning, sir. Do you have a lawyer today? What are you doing about that?
Can't afford a lawyer.
Did you even look for a lawyer?
Yeah, I talked to somebody and I was trying to come up with the money.
How many lawyers did you talk to?
Like 3 of them.
That may not be enough. Sometimes you got to look 10, 15. You know, what do you do for a living?
Paper.
How much money do you make a month, did you say? How much?
500 a week.
I'll have you fill out an application. Let me take a look at how much money you make, and then I'll see whether you qualify. But I'm telling you now, you got to meet the federal poverty guideline, and I don't know if you do. So I need to know everything about you. Be honest, because it's an affidavit that you're filling out.
Yeah.
Okay. Do you mind giving an affidavit? It should be right there, please.
Defendants Ayala and Johnson plead financial hardship to qualify for a public defender. The judge makes no promises. If they don't meet the federal poverty guidelines, they'll be on their own. It's a sobering reminder. Justice isn't free, even if freedom's on the line.
All right, Judge, next is page.
Oh, hold on, Vic. Let me just talk to him real quick. Yeah, of course. Come on up. Good morning, Miss Johnson. Do you have a lawyer today? Tell me what you're doing about that. You need a lawyer, 100%. You may have had one for magistration, meaning when you first were arrested, but that doesn't carry with you to the end. What do you do for a living, man? What kind of money you make a month? Or let's do this. I'll have you fill out an application. I'll see whether you qualify. I need to know everything about you. How much money you have coming in, how much money you have going out, how many kids you have, and then I'll see whether you qualify, okay? So let's start. I don't remember anything about the case, so if you don't mind me reading what happened, please.
So,
Okay.
you wanna?
Oh, so for this case, the officer was dispatched to a disturbance in Harris County, Texas, where the complainant and the witness stated the defendant had been texting and posting on Instagram about wanting to fight the complainant. The complainant and the defendant were inside an apartment when the fight began. The witness stated she observed the defendant to have a small, sharp blade in between her knuckles when hitting the complainant. The defendant punched the complainant in the face, causing lacerations and pain, and the defendant told officers that the complainant believed that the defendant was with the complainant's ex-boyfriend, which is what started the fight.
A fight and there's a blade and
Blade.
just,
We are going to get this case re-indicted most likely because she was also pregnant at the time.
Yes, Judge.
And,
okay, what do you want?
I'm just requesting that for the time being, the bond conditions be amended to no contact with her mother, Crystal Williams, due to the complainant notifying me that she has been going near the mother's residence and also threatening her mother.
Who's the complaining witness in this case?
The complainant is Demiracle Williams, Judge.
Okay. And does she live with mom?
She does not live with mom. They live at different residences.
Because I really don't know if I can, you know what I mean?
I understand.
So have her call the cops
Okay.
if she's in fear, you know, if she has anything of this nature, but I can't, on the complaining witness, okay, but on just an average other person, I don't think I can, you know?
Understood.
But like I said, if she's ever in fear, if she has any issues, tell her to call, 911, call the cops, and then they can take it further from there.
Thank you, Judge.
Be careful. I'm going to protect my community at all costs, Ms. Johnson. Do you understand? All costs. That you see from me. What conditions do we have now? Just no contact with the complaining witness?
So as of now, we have
No contact, no firearms. Judge.
No. Try the RIP again. See if there have been any further, issues and who do they live with? So,
yes, Judge.
but all right, Vic, you ready?
No.
Shenica Smith, come up. I'm printing this out for you.
I did speak to Wilvin Carter, and he advised that he had spoken to Ms. Smith as well regarding the possibility of this being the result. He and I spoke to her again just a moment ago. We were out there on call, and at this time, Judge, Ms. Smith, that we were going to have her speak on her own behalf, Judge. So I think it's important for her to take ownership for what this report shows.
I don't care. I'm putting an ankle monitor on you now. If you ever test positive for alcohol again, I'm going to put you in jail. That's it. No means no. Doesn't mean it's the holidays, doesn't mean I have a birthday. A court order is a court order. And when you don't follow court orders, there's only one place that we have you go. There's no tolerance anymore. And I don't care what you come up here and say, whether it's mouthwash, a tequila lollipop, hair dye, I don't care. And I don't care who you're with. A second violation. Do you understand? Today you will get an ankle monitor, and I'm going to tell you now, it's extremely finicky. So best beware of anything that you put in your body. Okay, no more. That's it. Okay. As far as the other, I don't know. What I would suggest is, email if you can now, Brenda Gomez, and see how we handle it, because I don't know. All I know is that this case is nearly 200 days old, and now we have violations, and I'm ready to put this thing to bed. I'm not going to hold it anymore.
Yes,
So,
understood.
I'll give you guys to the end of the week, figure out what we need to do.
Okay.
But you're walking a very, very thin line. Do you understand? All right, so Felicia, if we can amend it to put it on today, please. Yes, ma'am. Good morning, gentlemen. All you guys have picked up criminal cases, and you all have worked out agreements with the state and with defense to end up pleading guilty to these cases. You are Mr. Webb. Mr. Webb, you stand charged with the offense of criminal trespass. You're facing up to 6 months in jail and or a $2,000 fine. Mr. Rubio, you stand charged with the offense of criminal trespass as well. You're facing up to 6 months in jail and or a $2,000 fine. And Mr. Gerard, you picked up a number of cases while you have been on bond. However, it looks like you have worked out an agreement. You have a total of 4 cases, and it looks like they are going to dismiss 3 of them in exchange for your plea on one of them, which is the theft, where you're facing up to 6 months in jail and or a $2,000 fine. You now have at least 2 on your record. So what happens on the next one?
Felony.
Right. Instead of days, you were looking at years. So no matter a pack of gum, a pack of smokes, you could be looking at years in jail. Do you understand? All of you are giving up valuable rights by entering this agreement. You give up the right to a trial, right to compel witnesses to testify on behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you plead guilty, it will go on your record, and you cannot take it off ever again. Is this what you guys want to do?
Yes, sir.
Is this what you want to do, Mr. Rubio?
Answer out loud.
Yes, I
Mr.
don't know.
Yes, sir.
Do you want to do this? Yes or no?
I don't know. I'm not sure. I don't do. Yes.
Do you know what's going on now?
Yeah. Not really.
You were charged with a criminal offense. You've worked out a plea bargain agreement that you want to plead guilty to a criminal trespass. If you don't want to, you don't have to. We can do something else. If you need more help, we can give you time to get any kind of help that you need.
Okay.
What would you like to do, Mr. Rubio?
I'm not sure. I don't know. I've never been here before.
Okay, so let's give you a second. I'll have you talk to Lori. You guys can work out what you guys want to do.
Okay.
If you need more time, that's okay. Mr. Webb, is this what you want to do as well?
Yeah.
So-
I'm gonna plead
You wanna
guilty.
plead guilty?
Yeah, so they've offered you 32 days in jail. We'll give you credit for the 32 days that you've done. So basically, it's a wash. You get out today, but understand from now on, it's a minimum of 30 days in jail.
Right.
How do you plead to the offense of criminal trespass, sir?
Guilty.
I'll find you guilty, and I'm going to send it to you to the agreement. Good luck to you, sir. Mr. Gerard, you've worked out an agreement. It's 5 days in jail, credit for the 5 that you've done. How do you plead to the offense, sir?
I'll plead guilty, sir.
Sir, I'll find you guilty. I will follow the agreement. If it's enhanced, be abandoned. Mr. Rubio, if you want more time, we'll give you more time. You can come back and let us know what you want to do. Okay?
Yeah.
Gentlemen, go ahead. This report.
Careful, man.
Mr. Gerard, can you please go?
Come on.
Go.
No, that way it's easier for them.
Okay.
Morning, Mr. Reyes.
Good morning.
Mr. Reyes, you're charged with driving while intoxicated. You're facing up to a year in jail and or a $4,000 fine. You guys have worked out an agreement. They're offering you 3 days in jail. Credit for the 1 day that you have served. You
Yes.
need to understand that this charge will go on your record. It's going to be there for the rest of your life. From now on, you'll be facing a minimum of 90 days in jail for any cases like this that you pick up. No more proverbial slaps on the wrist because you now will be facing a minimum of 90 days. You get pulled over. The only thing an officer is looking at is your prior criminal history. If they see that you have a prior DWI, they come up to your car and you smell like alcohol, what do you think they're gonna do?
Arrest me.
Right. I would never, even if you've had a drop of alcohol, get into a car because you're taking a humongous risk. You give up a lot of rights by entering into this agreement. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. Once you plead guilty, it will go on your record and you can never take it off. Are you sure you want to do this?
Yes.
How do you plead to the offense, guilty or not guilty?
Guilty.
I'll find you guilty. I'm going to send you to the 3 days in jail, give you credit for the 1 day that you've done. I'm going to suspend your license for 90 days. Do not drive until you get a license. Tell me about him, Robert.
Judge, he's a chef in a restaurant. He makes between $500 to $550 a week. His wife does not work, stays at home with the kids. 5 kids, 17, 2 twins, 15 years old apiece, 3 and 5 years old.
I'm asking you these questions because there is a $4,500 surcharge that you have to pay when you pick up a DWI and you plead to it with a breath test of this magnitude. Your lawyer is asking me to waive that fee. I will reluctantly do this, but I'm going to tell you now, if you come back with another DWI, it is a $6,000 surcharge, not to mention court costs of around another $500. So you pick up another DWI, not only are you facing 90 days in jail, but another $6,500 to $7,000 in fines and fees. Do you understand?
Yes.
Don't come back or there's going to be you know what to pay. Good luck. Thanks, Ed.
Good morning.
Hi, Mr. Newley. How are you?
Yes, sir. Fine.
See you.
You have to play him out on a 12 months deferred.
Shh. What's
12 months deferred.
what's the name?
His name is Mr. Arias, A-R-I-A-S Rangel.
Good morning, Mr. Arias Rangel. Sir, you were charged with theft. You are facing up to 6 months jail and or a $2,000 fine. You guys have worked out an agreement where they're offering you a 12-month deferred. That is a type of probation that if you successfully complete, you do not end up with a conviction on your record. But you cannot tell people it was dismissed. It was not dismissed. Shh. You merely took a probation and completed it successfully, and you don't end up with a conviction. Do you understand?
Yes.
You also need to understand that you give up many valuable rights by entering into this agreement. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you plead guilty and once you accept this probation agreement, you were stuck with this until you complete it successfully, or if you get revoked. Now, I told you that the great thing about this probation is that if you complete it, you don't end up with a conviction, but you give up nearly every right known to man by entering into this agreement. If you violate this agreement, I can put you in jail for up to 180 days. Do you understand?
Yes.
If you pick up a new case, if you don't do any classes on time, if you do not do your community service, we will issue a warrant for your arrest, put you in jail, bring you back out, And if they prove to me that you've...
In a rapid-fire sequence, plea deals are handed out. One woman faces a blade assault charge. Others plead to theft, trespassing, or DWI. The judge delivers reality checks on every deal, reminding them of what they're giving up and how the consequences stack if they ever return. This is the law in motion. Don't forget to like the video, subscribe to the channel, and we'll see you in the next video.